Good morning.
Morning.
Welcome to a Zoom oral argument session here at the Fifth District Court of Appeal. I'm Judge John Harris. I'm presiding over the hearings today, joined on the panel with by Judge Rand Wallace and Judge Jordan Pratt. The hearing today is being recorded, live streamed on YouTube. This time, if you have any electronic or noise-making devices, please go ahead and make sure they are silenced or turned off so that we're not interrupted. We've got three cases set for this morning. The first two have been kind of running together because the arguments below and on appeal seem to be the same. The attorneys are the same. The panel has decided to consolidate the arguments, so it'll be 20 minutes per side for the two cases combined. Appellant, you can reserve as much of that time for rebuttal as you would like. The default will set it at 5 minutes. If you want anything other than that, please just let us know and we will accommodate you. If you happen to have any case-specific arguments, just let us know at the time which case you're referring to. So at this time, let's go ahead and get started. Case 24-1997 and 24-1998. Ms. Caswick, you may proceed.
Yes, thank you. 5 minutes for rebuttal is fine. Good morning, Your Honors, and may it please the court. My name is Rose Caswick, and I represent the appellants Lauren Palazzini and Dominique Tucker in their claims against their former employer, Advent Health Ocala. These cases were brought by the appellants against their former employer for assault, false imprisonment, and intentional infliction of emotional distress after they were made to fear for their lives during an unannounced active shooter drill conducted by Advent Health on one of Advent Health's campuses, in which the appellants and their cohort of 10 nurses were held at gunpoint at the direction of their supervisors for a period of approximately 10 minutes, traumatizing them, causing them to fear for their lives.
Ms. Caswick, I guess I don't know if this is semantics or not, but to make someone have a feeling, I don't believe that's possible. Is it correct? I mean, so they may have chosen, and it may have been a subconscious choosing, but to say they were made to feel a certain way, I don't believe that there's authority for that. Would you agree?
Your Honor, I guess it is a semantic situation where the plaintiffs or the appellants did feel that way. The appellees supervisors who put on this drill, before we get into the intentional misconduct aspect of it, had knowledge that they were doing these actions, that they would potentially be causing these harm, that they would be likely to be causing this type of harm to my clients. The fact that they felt emotional distress is really an issue for compensatory damages. The issue on the punitive part is that they knew that their actions were wrongful and they knew that their actions were very likely to cause this emotional distress in my client.
Counsel, can we talk about that for a second, just that knowledge or that intentionality? Would you concede that at least as to assault and battery, the intent to engage in wrongful conduct is not an element of those torts? So, for example, my understanding of battery and assault is an unwanted, apprehension as to assault or an unwanted touching as to battery. And my understanding further is that those torts do not require an intention to engage in an intentional tort. Am I wrong about that, or do you see things differently?
No, you're correct, and we have not made any battery claims. We do have an assault claim, and we do have an intentional infliction of emotional distress claim, which does require that element of malice, of intentionality to cause that emotional harm. That is not, the main thrust of our arguments on appeal or in the trial court. Those torts happen to run together, those intentional torts happen to run together and have related standards to the punitive damages standard. We cited those cases in our
Okay, so at least as to the assault, then, it sounds like assault is not an ipso facto tort, meaning that, the mere commission of an assault in a tortious sense does not necessarily entail an intention to engage in wrongful conduct. Would you agree with that?
So I wouldn't disagree with that. There is case law, specifically the CMR Marcy versus Montanaro case. It's 508 Southern 2nd, 1282. It's a third DCA case from 1987, which discusses that punitive damages are recoverable where malice is one of the essential elements of the tort. There's the Donegan versus Nevins case, 785 Southern Second 573, a fourth DCA case that discusses in the instance of intentional infliction of emotional distress, that the elements that you must complain for an intentional infliction of emotional distress and a punitive damages claim run together. And then there's also the Alt v. Lower case, 538 Southern Second 454, so Florida Supreme Court case that says a finding of liability for assault and battery in those cases will support an award for punitive damages. So
which of those cases post date the enactment of the punitive damages statute?
So the CMR versus Marcy case is a 1987 case. The Donegan versus Nevins is 2001. So I believe we're talking about a statute from 1986. Those are both post statutory enactment. And so when we're looking specifically at the intentional infliction of, the intentional misconduct in this case, we're looking at the 768.72 definition of intentional misconduct, which is that the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct resulting in injury or damage.
What
Here-
makes conduct wrongful? Is there a definition of wrongful? Is
I
it
do not
more than
believe-
something different than ill-advised or even stupid? What makes it wrongful under the statute?
I believe there's not a definition of wrongful, but it seems to be interpreted in a way that it is that what they knew what they were doing was wrong or improper in some way. And here what we've got is Hankinson, one of the nurse educators who put on the drill, testifying that they wanted to make it as realistic as possible, that their biggest concern in putting on the drill was that the participants would become combative and try and attack the person portraying the shooter. They were concerned that the participants would be afraid that they were going to run out of the room, that they would not be able to get them back. And I believe that testimony is indicative of their knowledge that what they were doing was wrong. They intended to scare them. They intended to make them feel that they might need to fight for their lives or run for their lives. And you don't have those concerns going into this situation if you don't believe that you are going to be causing harm and going to be inducing those feelings in the participants.
Wasn't there also a history, though, of a previous drill or exercise where I believe the employees did not take it seriously and or I guess mocked or degraded or joked about the previous exercise?
So there was a previous drill, and that is part of this case, is that the people who put on the drill, Hankinson and Torrance Zardine, intentionally ramped up this drill to make it more serious, to make it scarier, to get the reaction that they wanted out of these participants, which was the fear. The other class did not get afraid. They wanted to ramp this up and get them to be more afraid by adding the gun, by adding the gun, well, the gunshots were in the first one, but by adding the gun, by having him come into the room, by having him conceal his identity, they wanted to induce this reaction in the participants. And Hankinson, I believe, testified that the reason they kept the drill ongoing, even though they could see that everyone in the room was terrified and cowering in the corner, is that they wanted to get more of a reaction from them. The nurses, my clients, weren't doing what they wanted them to do. They weren't fighting. They were just cowering in a corner, crying and huddling up. Anyone in that room and everyone who was in that room and testified about being in that room testified that they knew these people were in distress, that they were cowering in the corner, they were crying, they were shaking, they were trying to stay out of the line of fire. That was the other participants in the class who are not parts of any of these lawsuits. That was the sheriff who came in after the fact. That was Travis Gilman.
Counsel, what I'm hearing from you is you're walking through, it sounds like, the elements of intentional infliction of emotional distress. And as I understand it, this appeal concerns the separate question whether or not you have established an entitlement to plead punitive damages. So is it your position that establishing some evidence for each of the elements of intentional infliction of emotional distress ipso facto results in an entitlement to plead punitive damages? Or is there instead something in addition to or over and above the elements of intentional infliction that you think that you've satisfied? And if so, could you walk us through how that is?
Right. So the arguments are very similar. I am specifically speaking about the intentional misconduct definition that is in the punitive damages claim. That is the definition that we are talking about here, that there was actual knowledge of the wrongfulness of their conduct and the high probability of injury or damage. That is what Hankinson demonstrated in the testimony that I just talked about. Beth Torrens Nardine spoke about a prior situation she was involved in where she was confronted with an active shooter, and that put her in therapy for years. She had literal, real knowledge of the harm that putting someone in the path of an active shooter could cause because she demonstrated it itself. That goes directly to the definition of intentional misconduct from the punitive damages statute. And when we're looking at a motion to amend to leave to amend to add punitive damages, we're looking at whether there's a reasonable showing, whether there's a reasonable basis. There should be a legal determination made that, and this court's ruling in Werner Enterprises 362 Southern 3rd 2278 said that that is a legal determination that is similar to the standard that is applied to determine whether a complaint states a cause of action, and that the evidence should be viewed in the light most favorable to the plaintiff. So we are not saying that there's not conflicting evidence one way or the other in this case. We are saying that there is a sufficient basis, there is a reasonable basis, and that we're not on a summary judgment standard. We're not, finding facts here. We're not invading the territory of the fact finder. We are looking at whether a cause of action was stated and whether the plaintiff can reasonably proffer evidence that would satisfy those claims ultimately.
What's the evidence that these folks knew that there was a high probability that injury would occur or result from this?
So that is what I was discussing with Beth Torrens.
Just the fact that the one nurse had that prior experience?
Well, that's part of it. I think there is a common sense element to it that if you're going to hold someone at gunpoint, that is, highly outrageous and upsetting to anyone who would be put in that situation. We've got, their intent to make this a more intense and more frightening situation. We've got that these nurses, almost everyone who's testified in this case has talked about other types of simulations or drills that can be done that are done in a controlled environment, such as a code blue. They work on a dummy trying to perform life-saving measures. That is done in.
If we could just back up for a second, you mentioned holding someone at gunpoint. Just maybe a little small factual clarification, but am I correct in understanding that this was not a real firearm? This was some sort of a mold that may have even been a different color, right? Like blue or something like that. And was there any testimony that the nurses actually saw this mold and believed it to be a firearm? Could you clarify what the record says about that?
Yes, Your Honor. Everyone who has testified, my clients, as well as the other nurses who were involved in the class, testified that they saw the gun, that they believed in the moment that the gun was real. It is a mold of a real firearm. It is like a dark burnt orange color. It's like brown. So everyone that was there in the moment, they're not studying the gun, obviously, but they are looking at it and they truly believed that they were held at gunpoint. Multiple people called 911. Everyone that testified that at least for momentarily, they believed this was a real gun in a real situation. Obviously, some of them stayed in that state of mind for longer and resulted in this trauma. That is part of our analysis too, is that even if the planning and implementation or the planning of the drill was 100% virtuous, they didn't think it was going to cause this this outcome. Once the drill was going on, they're in the room and they can see the harm that it is causing. They can see everyone cowered up in the corner, and that no one is learning in that scenario. Like I said, Hankinson testified that she wanted to keep it going because they weren't doing what she wanted them to do. Torrens Nardine testified that she was more concerned with interacting with the supposed shooter and de-escalating the situation. But they're not the ones that are supposed to be learning and getting anything out of this scenario. It's the nurses who are nothing but traumatized, nothing but terrified in that moment. And in fact, it was Travis Gilman, the shooter, the person portraying the shooter, who ultimately said, "This is too intense. I'm calling this off. We can't do this anymore." Hankinson and Torrens Nardine were going to keep it going. I don't know how much longer until they got the outcome that they wanted, I guess.
Counsel, could we spend a little bit of time, since you're running short on employer liability? And what's your best sort of fact in terms of like the highest level management that specifically knew at the time that the drill was planned, not after it was executed, but before it was actually executed, that there was going to be, a mold firearm and the clipboard and all of that?
Right. So I believe the testimony from the people who actually knew at the time was Yolanda Cook, the the education manager. But if you look at the standard for corporate liability, it includes that the employer, the officers, directors, or managers knowingly condoned, ratified, or consented to the conduct. Condoned and ratified are both things that take place after the fact. And when you look at that and take into account the condoned and ratified language, you're looking at Patricia Price, who is the chief nursing officer, who is in the C-suite. If you look at the organizational chart that the defendants provided, you've got the CEO alone at the top, and then this level of chief officers, and Patricia Price is in that level. She testified unequivocally at her deposition, being fully apprised of the facts, this lawsuit, everything else that was going on, that she agrees with the training that was done, that she thinks Advent should continue to conduct that kind of training. She believes they should continue to keep the drill unannounced, and that she would in fact advocate for them to continue doing this going forward, including specifically making the students believe that they are in imminent peril as an important part of the drill. That is 100% condoning and ratifying the actions of Hankinson and Torrance Nardine. You've also got the fact that they were, Hankinson and Torrance Nardine were basically given the authority to do this. They didn't need to ask for permission from anyone to put on this drill, to design this drill, to do any of the things that they did, because they had the authority. It was passed down to them from the top to design and implement this training program. So it would be nonsensical to say that the CEO can delegate the authority down the line and then claim, no knowledge of it, and therefore the company cannot be held liable. It creates an inequity as to large corporations versus small corporations, where in a large corporation, the CEO is much less likely to have any idea what's going on at the institutional level. And it encourages, the CEO to bury his head in the sand and create these arcane management structures where they can disavow any knowledge of anything going on down the line.
Ms. Craswick, you're about a minute into your rebuttal time. Do you want to reserve what's left?
I will. Thank you, Your Honor.
Okay, thank you. All right, Ms. Downs, good morning.
Good morning. May it please the court. My name is Mayanne Downs, and I'm here representing Advent Health Ocala. I have my colleague Savannah Clifton and my law partner Brock Magruder, but off camera because of technical problems with us, mine this morning. Thank you. I know this court is well familiar with the facts as evidenced by the question, and that we have 2 appeals. So I want to try to focus on the key components of the facts and the law. And I do want to start with 768.72's focus on and inclusion of the phrase personally guilty, because that's actually a concept that goes back into the 1900s about the fundamental fairness of holding a party responsible for punitive damages in any circumstance in which that party itself is not guilty of some level of fault or contact that would make you. Yes,
Ms. Downs, could you speak to what was the criteria that was in place for purposes of this drill, which would result in the drill ending? Like, what was the end goal, and what were any specific criteria that were listed to meet that would then result in the end of the drill?
That would result in the drill ending when it did, Judge Wallace?
Well, not the way it ended, how it did. In this case, I believe there was an independent decision made by whoever the person who was carrying the fire, the simulated firearm.
Yes.
That
Yes,
that person determined on their own to end the drill. But I want to know, leading up to the execution of this specific drill, what were the criteria that the management was seeking to achieve, which once you achieve that criteria, the drill would end?
The only managers, by the way, were the two nurse managers in charge only of curriculum and running this drill. The context in which this drill occurred is that the day was entitled MCI, Mass Casualty Event, Stop the Bleed, Active Shooter. That was the name of the training day. That's what the sign-in sheet the plaintiff signed said. That was the focus of the training. The point, as evidenced by the evidence from both nurse managers, is that the parties, that the nurse residents would have an opportunity to feel and understand the sense of urgency that overcoming their fundamental instincts might provide to them, to give them a skill to automatically think of escape from the room, alternatives to doing whatever it is that the person with the violence tendencies was going to do, giving an opportunity for others to do something, then huddle in the back of a room. There was a list of criteria and skills that both nurse managers hope to impart, albeit not good decision-making, obviously, to these people to get their attention and then have them think through, what could I have done? Specifically, for example, as the drill began, one of the nurse managers made a point of getting up and walking out of the room to illustrate that the door was not locked, that there were exits available. Another nurse purported to negotiate with the alleged gunman and say, I'll go get the drugs for you, again, to illustrate other opportunities. The drill was called off, as you know, very quickly, so those things didn't occur. In fact, the first 911 call occurred, and 2 minutes later, Deputy Sheriff appeared on the scene. That will give you an idea of how quick it was, somewhere between 5 and maybe approaching 10 minutes. But that was the concept, that was the idea. But in terms of knowledge, and the panel was just speaking of that a few moments ago, I want to go straight to Pam Price's testimony.
Before we get to the testimony, counsel, can we just
Yes, Judge.
just when it talks about having actual knowledge of the wrongfulness of the conduct, you know, I mean,
Yes.
we hear the phrase over and over, ignorance of the law is no excuse. But is this, in your view, an instance where the statute requires knowledge not only of all of the particular elements of the tort, that the person is engaging in all of the particular elements, but that the person also has to know that the conduct is tortious and wrongful? Like, is that what it means to know that something is wrongful, that they have to actually know that it's unlawful or that it's tortious? Is that your view?
Well, if we use the word wrongful as a substitute, which I think it fairly is for the word tortious, a wrong, the legislature has told us the level of wrongful knowledge. It specifically says in 762.72, intentional conduct within the context of this determination for personal guilt and punitive damages means that the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued the course of conduct.
Right. And
resulting
my
in
question is
injury
about
or
the word
damage.
wrongfulness. Does wrongfulness mean
Yes.
contrary to law, so that the person, you know, who acted has to actually know in that moment that their actions are contrary to law? Right? Is this an instance where, you know, the maxim
Yes.
of law is no excuse is
Right.
actually not applicable? Is that your view?
I think wrongfulness there means that you know it is wrong in the sense that you have malice, that you intend to harm. That's the difference, not intent to do the act, but you have intent to harm that claimant. And that's a fundamental wrong, whether we call it a moral wrong or a legal wrong or an ethical wrong, an intent to harm another, knowing that that's malicious and that you intend that malice. By the way, as an aside, in assault and battery, the conduct of battery supplies the malice. You were asking Judge Pratt earlier about assault. Most all of the cases that talk about assault also talk about battery. So whether the individual defendant or actor understood the elements of a particular tort, I still think Judge Rogers was right when he said there is no evidence here that these two nurse managers intended to harm the plaintiffs. They intended to do the act that maybe they shouldn't have done it. Of course, they shouldn't have done it.
Well,
And ultimately,
now maybe
I'm sorry.
I mean, so there are two different possible ways to, look at this. One is the reasons why, the nurses that conducted the training, did what they did. And the other is, just purely what result they were looking to accomplish. And what I understand your friend on the other side to argue is, hey, they specifically wanted to invoke a feeling of fear and, apprehension in the trainees, right? And, what I understand you to be saying is, well, even if they, sought to invoke that sort of feeling, they did it for good and noble purposes, for a training purpose, rather than for a purpose, like in lack of a better word, a wrong purpose. But that's kind of the rub, right? I mean, the rub is, wrongfulness of the conduct, does that focus merely on, whether or not it's tortious, right? Because to intentionally inflict emotional distress is a tort. And, I guess, is it your position that, we're looking at something more than that? And that we're looking at maybe the purposes for which emotional distress was allegedly intentionally inflicted? Is that sort of what you're getting at?
I think the purpose is part of the context. The fact that there was an active shooter, words written on the sign-in sheet, the fact that they spent an hour going over the Las Vegas shooting, the fact that it said stop the bleed, the fact that the nurse managers gave cues and clues to the students before it began, the fact that they all stopped the drill when it became clear that some of the students were upset. But I would say it's more than just the purpose, Judge Pratt. I would say is the point here is there evidence that would reasonably establish that the nurse managers intended to harm. They intended to get the students' attention. And that's what Judge Rogers said. But there's no evidence that they intended harm. They called it off. They gave some cues. They gave some clues. They had their own reasoning about why they thought getting the attention of the students was important and critical. But nobody has suggested there was any malice, the kind of malice that the law has long required to justify the extraordinarily high remedy of punitive damages. But if I might shift momentarily and say,
Well, let me stay on this for just a second.
Yes, Judge Harris.
Is the law that you have to intend for that harm to occur? I mean, you cite the Perlmutter case in your brief, and it talks about the intent to knowingly engage in wrongful conduct. That's where intent comes in.
Well, the statute itself says actual knowledge of the wrongfulness and high probability that injury or damage to the claimant, to these claimants, would result. And despite that knowledge, intentionally pursued that conduct causing injury. That's
so
what
the
intent
goes to the act itself, not the intent to harm. You have to be aware there's a probability that harm could result, but do you have to intend to harm the claimant?
Yes, I believe that's what the Florida legislature said and you're right, it is a higher level of intent. It's not intent to do the act. It is intent, it is malice that allows an actor to do something they know is wrong, and they have believe there's a high probability of damage that will result from their action. That is a high level of intent, and the statute also the specificity of the intent. So yes, Your Honor, I would say this is a higher, more specific, more meaningful level of intent specifically set forth in this statute for the purpose of determining whether punitive damages.
Do you acknowledge in this case that running the drill in the manner that they did it was, again, in this case, wrongful?
I think it was stupid. I don't think it was the wrongfulness of intent that this statute requires, Your Honor.
Did Advent Health acknowledge that it was wrong to do it that way by almost immediately adopting this
Yes.
what we call after action plan?
Yes, yes, in fact, and that's part of Nurse Price's testimony. Just a reminder, Nurse Price is the head of nursing education. She's not even the head of the emergency room, but she is in charge of nursing education. And she was told by Kim Laux, hey, this drill happened. Nobody knew all the details except the two nurses who ran it. We've got some very upset nurses. Rest of them are fine, but we've got some upset nurses. She was immediately told to put together an after action report. It is a written report. It identifies the problems. Page 2 of the action report details numerous debriefings, questions, investigation into how this happened, and then a flat determination that it will never happen again, that all nurse residents, staff, external law enforcement, everyone will know about a drill. Weapons will not be used, or this was an orange plastic weapon, but that doesn't change the fact that it shouldn't have happened and that it was a mistake. So
I mean,
yes,
obviously
Your
you're
Honor.
arguing that that it's not going to happen again because you want to show that the deterrent goal of punitive damages does not apply here. Because you said, we're not
Yes,
going
Your
to do
Honor,
it anyway, no matter what. Doesn't that seem to acknowledge or admit that the conduct itself was wrongful?
It
It was
admits
certainly
that the
intentional.
conduct, that it was a mistake, that it shouldn't have happened, that the nurse manager shouldn't have made that decision. Should have sought the advice and counsel of people in the organization. Yes, it should never have happened. That doesn't mean punitive damages have been established. And again, let's remember what the statute and the case law that says about the level of engagement that has to happen, because whether individual nurses think even after the fact this was a good idea is of no moment factually or legally. What the statute says is that the organization had to have full knowledge and condone or ratify. So the argument, hey, some of these people still think it was a good idea, they're not the corporation that's been sued. They're just people who work there.
Ms.
And what the
Downs?
statute, yes.
So in the record, it says that Torrens Nardine informed the students that there could be a drill at any time that day. Was there any evidence before the trial court as far as the span of time that occurred between the time that they were informed of that and the time that the shooter, that I'm going to call the shooter in this case, started to rattle the exterior door?
Well, there is no precise amount of time, but it certainly would have been less than 3 or 4 hours because that was the time period that encompassed. The drill was before lunch, and the day started at 9 or 8 or something like that. So yes, they were told there would be a drill. As I said, the title of the day was "Stop the Bleed: Mass Casualty Active Shooter." So there was some knowledge there.
What was the time frame between, I believe it was described as they were having some sort of a roundtable discussion and when the rattling occurred to the exterior door? Was that as they were in the middle of that conversation?
That would have happened a couple of minutes into the conversation, Your Honor. So in other words, they were giving introductory comments about shooters, about drills, stop the bleed, mass casualty. What they had just been looking at, there was a FEMA representative there showing video about the Las Vegas shooting, telling the nurses, hey, here's what you're looking at: massive bleeding, transportation, emergency, all that kind of stuff. And then they said, now we're going to the round table part of the exercise, and they began to describe the kinds of issues that could come up in a violent situation in a hospital, and also the hundreds of those events that occur every year.
That was simultaneous. That conversation is going on as the actor then starts to rattle the exterior door. Is that correct?
That's right. Mr. Gilman comes from the outside with a clipboard making noises and then rattles the door. That's correct, Your Honor. During that, that's the way it was planned to occur. But I just want to get back briefly to the importance of Ms. Price's testimony. Her position does not include being involved in education for new nurses. The first time she heard of the drill was when Kim Laux tested her afterward to let her know that nurses were upset. She knew that a drill was happening, but no details or particulars at all, not involved in the planning of the drill. Heard about it also from Yolanda Cook several days later. So there's no question that, Nurse Price is not a managing agent of the entity. She isn't even in charge of the whole emergency room. She's in charge of nurse education, falling far below the standard of what the statute requires. There has to be knowledge and then ratification. What happened here is when Advent management found out about this, they directed an investigation, an after action report, and adopting rules to be absolutely positive this didn't happen again. Yes, it was wrongful. No, there has not been sufficient evidence in this record to justify what Florida statutes require to hold Advent liable for punitive damages when it knew nothing of the events, had no advance planning, and did everything it could to curb it ever happening again. Thank you, Your Honor. I'll try to finish a moment early.
All right, thank you very much. Okay, Ms. Kraswick, you have just under 4 minutes.
Thank you, Your Honors. To address the issue of Ms. Price's testimony, my colleague, Ms. Downs, discussed that Ms. Price is the head of nurse education. That is not my understanding from her testimony. That is not my understanding from the organization chart. She is the chief nursing officer. She is the head of not just emergency department nurses, but all nurses in the
Does that make
Advent
her a
Health
managing
Account.
agent?
It makes her the institutional decision maker over all nursing decisions, which gives her managing agent authority. That would be our position, that we have not been able to depose the CEO. She is directly under the CEO. She is, she's not making decisions on behalf of Advent Health Ocala and their nurses. I don't know who is.
When you say that she's directly under the CEO, you mean she reports only to the CEO, directly to the CEO?
Correct. She is that second tier of the org chart. If you want to look at the after action plan that was put into place, or that was created, I'm not sure though it was put into place, but that was created. That was developed by Kim Laux, who is the head of the ER, who is beneath Patricia Price in the organizational chart. They put in this, this report acknowledging that what had been done was wrongful. And even then, their higher up, Patricia Price, says we should do this again. We should do it exactly the same. We should do it and terrorize these people just as much the next time. So we've got a higher level person contradicting what's there in the after action plan. You've also got, I think, some red herrings about what else was going on in that training day. The mass casualty incident. An active shooting can be a mass casualty incident, but preparing for a mass casualty incident generally has nothing to do with active shooter. Active shooter has nothing to do with that. Stop the bleed is a term of art for how to stop bleeding in any type of injury. It is not, neither of those things have anything to do with directly being confronted with an active shooter in your face. And I believe the testimony from multiple people in the room was that the class had gone on to a tabletop exercise involving a mass casualty at the time that Mr. Gilman came into the room. And that is essentially a drill and a simulation on a much less, realistic level, where they can triage people and do what you would actually do in a hospital during a mass casualty event, rather than try and confront and take down a shooter.
Let me touch briefly on something that Ms. Downs brought up. You cite several cases in your brief where the courts have held that the intentional acts of assault and battery were alone sufficient to provide proof of malice. I think you cite the Raines case, Bryson, Holland, Joab, and others, I think. Are there any cases where just an assault alone, without the concomitant battery, was sufficient to provide that malice?
Not that I am aware of, Your Honor. I think the more relevant case to this would be the Donegan versus Nevins case, where the intentional infliction of emotional distress was likened to the claims that need to be made for punitive damages, a claim to be held. The prima facie elements there are essentially the same. So, and just to conclude, what we've got here is, the trial court overstepping its role as the gatekeeper, improperly weighing that evidence, making up its own conclusions about what should or could have been included in the evidentiary proper, engaging in, these red herrings and different issues about whether our clients were specifically susceptible rather than people being generally susceptible to being held at gunpoint, ignoring the fact that Hankinson and Torrens-Nardine knew that what they were doing was wrong, ignoring the fact that the chief nurse officer ratified their conduct, and allowing this to go forward. Thank you.
All right. Thank you both very much. A well briefed, well argued case. At this time, the court will stand in recess.